Most of my clients have very few assets, but from time to time I do run into people who have set aside money for their children and they've put the money in separate bank accounts for the children, and that can be very touchy if you're going to be filing a bankruptcy. Basically, there's three situations. Situation number one. Parents have set up what they call a 529 college savings account. It is a lot like a 401k, and with a 529 savings account, any money that has been in that account for more than 2 years before you file the bankruptcy is safe from the bankruptcy trustee. The bankruptcy trustee should not be able to take that. Anything that has been put in there within a year before filing is completely unexempt and can be clawed back by the bankruptcy trustee. More than a year before filing, but less than 2 years before filing, during that window, money deposited into the account up to the amount of $6,425 is protected. Situation number two. Parent sets up what they call a Uniform Transfer to Minor Act account. That's UTMA account. Now, money in one of these UTMA accounts might be subject to getting clawed back from the bankruptcy trustee if the money was put in by the parent and the parent is the one who is planning on filing the bankruptcy. Because in Minnesota we have what we call a fraudulent conveyance statute. The statute says that if money was transferred somewhere to hide it from creditors, it can be clawed back by a creditor, and if it can be clawed back by a creditor, it can be clawed back by the bankruptcy trustee. Oftentimes it's a transfer into an account for a child, and if that's the situation you have, talk with your lawyer about it. Third situation, it's just a plain old-fashioned joint account. The child's name's on the account, the parent's name is on the account. Well, this is especially touchy because we have another statute in Minnesota that says that if you have a joint account or a multi-party account, the money in the account is considered to belong to whoever it was who deposited the money. So if the money came from the parent, it might be an asset belonging to the parent that would be an asset in a bankruptcy case. Has to be looked at very closely. But if the money came from somewhere else, and this applies to the UTMA accounts too, if the money came from some third party, like grandma gave it to the child and the child put it in the bank account, chances are it can be protected because it belongs to the child. If you have a bank account that you have set up for your child, and if you are thinking about a bankruptcy, give me a call, we'll talk about it.